What what happened between 14 or 11 and now that made you go back and say, hey, I want to do it now? What happened to 16, 17, 18, 19,
I,
20?
I have called the state several times. I actually still have emails
So the
from
state, you mean the state
here.
board?
W- I don't know the official name.
Yes, she called the board.
Um, and to find out if I'm sorry, if I could become, if there was another way other than retaking the exam to become licensed. And I even asked, I have the email still of the licensing coordinator in 2018, January 2018. I asked the individual, when did this ruling become effective? And is there a grandfather clause for people like me? And he came back and said he didn't know when it became effective, and no, there's no such clause. And he said, maybe you can contact another state. And I did not approach it at that time. And I called again earlier. This is before they started following up with emails. I couldn't find any other emails before that, but I know I did. I have tried to go through a managing director at CBiz in Memphis, former colleague of his. This is Mark Baracos, if anybody knows him, to try to find out if they knew of any other way to do it. It was ultimately going through Watkins Uberall in Memphis that I found Wendy. I have tried to figure out another way around it. And to answer your question about continuing education, I will admit I don't have what you would consider the official CPE courses to list. But, sir, I am that person who buys books and reads them and researches and works very closely with my accounting firm to make sure that the processes that I create and manage are aligned with GAAP. And so I have not just coasted through the last 10 years. I have actually researched and talked with other accounting firms in Memphis. I've written policies that our company didn't have that were GAAP compliant. So, I don't have anything to put on my resume that says that I took this CPE course, but I have definitely put in the time to keep myself updated. The new revenue recognition around rewards points. My most recent company, Titan Brands, is a retail company, and they have a rewards points program. I had to read that reg. I had to figure it out. I had to figure out how it applies to us, and I had to work with our auditors to make sure that the process that I was creating was compliant. I also had to figure out the new operating lease regulation to make sure and put a process in place, even though for private companies, it's not, they weren't required to be compliant yet, but I wanted to put it in place well enough ahead of time so that there were no P&L surprises when we were required to be compliant. That's just the kind of person that I am. So I agree with you. I do not have anything on my resume to say that I have completed this list of CPE courses.
So from our perspective, I'm sure you can appreciate
I do.
what we have to do. We have to try to be consistent with everyone and fair to everyone. And like I said, you have certainly a good work experience that you've described to us here. But if you can put yourself on the other side of the desk here and think, what if everyone who passed the exam waited 21 years or 25 years to move forward with it? Have to go on facts and circumstances, and your facts and circumstances are certainly unique to what somebody else's might be. So that's why we're asking the questions. We're trying to
understand.
One last question. Do you have any, and like you said a while ago, back before the days of email, we don't document things as well as we do now, but I'm assuming you have no documentation that says back in 11 you were told that the
I do not.
10-year rule existed.
I do not. I actually forwarded Wendy Thursday, I believe it was, the very last email communication between me and the licensing coordinator. And in that email, in fact, I could only find, this is in my old computer that I call the dinosaur, that I can't actually connect with, but I can access the emails. And so I could only find 3. This is how much of that whole process happened by phone and by leaving voice messages on the phone. And so there was only 2 emails from the individual that helped me rebuild my file, and 1 email with the licensing coordinator, and this is the email that I'm referencing. And in that email, I had asked her several weeks before, send me an application. I had already rebuilt the file. That individual had sent it to the licensing coordinator. It all checked out, and they were ready to go. And I asked the licensing coordinator, please send me an application. I'm ready to go. I had a question about, where you have to prove that you've worked under a licensed CPA, and I didn't receive that application. So I very politely, 2 or 3 weeks later, followed up on that email and said, hey, I didn't receive it. Here's my address again. Please send me another one, which is another way of saying, did you send it? Here it is. And that's the end of the paper trail. And, it was, what happened was, if I recall, and I asked, Chris, it was a phone call. It was a phone call. And I mean, I just remember just listening like this, and that person repeating themselves, and me asking them to repeat themselves because I didn't know there was an expiration date to the grades. And I felt like an idiot, and I'll be honest with you, this is on the top 3 list of life regrets, the number 3. I'm not going to tell you the other 2, but, I mean, it is, and I understand it's been 27 years, but I tried in 2011 when I came back from being a stay-home mom.
Thank you.
Are there any other questions?
I have one more question, just for clarification. This is Stephen again.
Okay.
If just hypothetical, let's just say in 2005 that you passed your final
No,
test?
sir, it's 1995.
Or 95, sorry, 90, yeah.
Yeah.
Either way, let's just hypothetically assume she passed it. She passed the ethics exam, which she's done, and she had applied for a CPA exam. Then subsequent to that, she went inactive. And now, however many years later from that point, what would we require her to do? What type of CPE requirements would she have to get reinstated today?
Stephen, she would be required to, Karen, make sure I'm not wrong here. She required to get 80 technical hours within 2 years prior to the application date.
Okay. I have a motion, but if somebody else wants to talk, I'll be glad to wait.
Well, I had one question. This is Janet. I just wanted to clarify that before the rule change in 2014, there was no rule regarding an expiration of exam scores. Is that correct?
That's correct, Janet. And something that Gay and I talked about on Friday that you all do not have in your materials, I did a quick survey on Friday of other states and how they handle exam scores. In a majority of states, your scores do not expire at all. So, which is when she mentioned at the beginning maybe transferring her scores to another state. I don't know how they would deal with that, but she may be able to do that in order to get licensed because most states, your scores don't expire.
Do they have a CPE requirement if there's, I'm sorry, I didn't mean to cut in.
Go ahead.
I just wondered is there a CPE requirement if in other states, if say they waited 15 years or when they go to apply?
Stephen, Arkansas requires 120 CPE hours if 3 years have passed. Alabama, let's see, if you passed under the 120 hours of college hours versus the 150 hours, they give the candidate 36 months to complete that 150-hour requirement. But I think Arkansas was the only one that gave a CPE requirement.
Correct.
Okay. I just asked that because in my opinion, it should be somewhat consistent with the reinstatement. I think that's just me. I mean, if you're going to make somebody's going to take off that amount of time just because they fill out the application, I think that there should be a similar CPE requirement just to get up to speed.
Yeah, this is Janet. I agree with that as well, Stephen, that it seems like it should be consistent with a reinstatement or something along those lines if we were going to do that. And because it doesn't appear to be uniform across all states, that exam scores do expire. Not that I'm on this committee, but my opinion would be it would be appropriate to extend the scores.
Pam, did
Can
you?
I ask a couple of questions?
Yes,
Yeah.
ma'am.
Okay, first of all, am I right that she said shortly after she passed the ethics exam, she inquired, and then she went through the whole thing of having to get her file rebuilt. It seems to me if she inquired in 2011 about becoming a CPA, and we said, oh, sorry, we can't help you because we've got to build your file, and then we said, oops, you can't do it. I think we have to go back to 2011 and act like we hadn't given her the wrong information in 2011. It seems to me that, if there was some rule, which apparently there wasn't, that had said that she wouldn't be able to do it anyway, that she shouldn't have been told to rebuild a file, et cetera. Anyway, my point is I think we have to sort of roll the clock back to January 2011 when she was given erroneous information. Secondly, how was she allowed to take an ethics exam? Do you not have to have something to say you're ready to do that and log in, et cetera? How does that work?
No, I don't believe so, Pam. It's provided by the AICPA, and it's similar to a CPE course. You simply go on and register for it and pay the fee and request a scoring.
Okay. Well, I had the same thought as Stephen and Janet, that if she'd gone inactive, that she'd have to do CPE. Now, I will say, I just think we sort of have to ignore the fact that there's now a limit as far as expiration. But given the whole complex set of circumstances, I think some CPE is reasonable. I don't think we should be concerned about what she's done in her career, what she will do, because we don't do that for other candidates. But I do think some CPE would be reasonable.
Okay. Thank you, Pam. John. All right, so what I'm hearing from people is we would accept those scores. We would apply an extension to it, but I'm like Stephen. I think an 80 hours of technical CPE to be performed, would that need to be done before she makes application? Is that?
I would say so, and Maria, you may have to help with the legality here, but I think we need to set some sort of framework here. So if the committee requests 80 hours of technical CPE, then you probably need to give her a date that you would extend those scores to and give her time to get the 80 hours. And then if she doesn't do that by then,
Okay.
I don't want to leave it indefinitely.
Okay.
What is the reinstatement requirement? Like, how much time, if you're getting reinstated, to do the 80 hours do you get?
It's 80 hours within 2 years of your application date for reactivation.
I mean, I'd prefer to keep it somewhat consistent with that.
Is that the same for if you're inactive?
Yes.
Trying to go to active?
Yes, so the reactivation, that's the requirement for reactivation. If you're reinstating, when somebody reinstates, it's that you have a license not in good standing, so it's expired. And those those individuals have to obtain 80 hours of technical CPE within 6 months of the application date.
But if you're inactive, is that what you were saying is 2 years?
Correct.
Okay.
I mean, from hearing her talk, I don't think timing is going to be an issue. I mean, I think she just wants an opportunity to get her license back. I want to be fair. I mean, I I'm always about being consistent, but I mean, to me, 1 year seems like a reasonable time period. 6 months is probably a little too short, and 2 years is probably too long. But
Stephen, are you making a motion?
I will. I'd like to make a motion to recommend to the board that we grant an extension of her CPA exam scores with the condition that she will attain 80 hours of technical CPE within 12 months from today.
Stephen, would you like to include 2 hours of state ethics in that 80 hours?
I think as part of that, yes, it needs to be the 2. Yes, okay. Good point. So 80 hours of technical, including 2 hours of state-specific ethics.
And with a 12-month extension of her exam scores.
Correct.
Okay. My understanding, we have a quorum on the premises, so we don't have to do a roll call vote, but just a...
We'll just need to do a regular vote.
Regular vote, okay. All members of this committee that are supportive of Stephen's motion for a 1-year extension of Ms. Farrell's CPA exams with...
Gay, pardon me, I think we need a second to the motion before we can...
I'll second.
You'll second?
Thanks.
Okay. Any discussion? All right, if not, all those in favor say aye.
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 Any opposed? Okay. Ms. Farrell?
Thank you so much.
Let me clarify that this is the committee. So
Yes.
a final vote will be taken tomorrow at the board meeting. You're welcome to dial in tomorrow if you'd like, but the committee will make the recommendation to the full board tomorrow.
Congratulations.
Thank you so much.
Thank you, Ms. Farrell. Appreciate your attendance and advocacy for your position today and the response to the Q&A.
Thank you.
Okay. We'll get back on track for our scheduled agenda. As a reminder, exam credits back in 2020, all credits that were expired from April 1 of 2020 through December 30, 2020 were extended until December 31, 2020. Then later, because of continued COVID issues, we approved additional extensions where those that expired between December 31 of 2020 to September 29th, 2021 would be extended until September 30, 2021. So that's laying the groundwork for a few decisions we need to make today. Our first individual is Chase Bowling. Is that the way you... Bowling? Okay. He is requesting a 6-month extension on his VEC credit that was passed March 6th, 2020. This was right before the shutdown. And his part extends naturally, meaning he got no extension available to him. It expires on September 30, 2021. Just like a lot of people, he was stuck. He could not sit for 6 months. The first available sitting for another part was September 11th of 2020, and he's just requesting a 6-month extension on this BEC credit. So, any comments, thoughts?
How's he different from? Is it because he passed the part that he passed earlier than?
Yes, and it naturally expires on September 30 of 2021, but he still was blocked from sitting for the exam, for sitting for other parts during a 6-month period.
Qualify for the extension we gave through December. Okay.
Didn't qualify for anything. So he's requesting 6 months. Any thoughts?
I'm still sort of confused on the dates. All this is, when he says May 22nd, he was signed up for May 22nd, 2020. So could someone help us think about how does this differ from other people in that situation? I know it's, he mentions his specific testing center, but we gave the extensions because we knew test centers would be closed. Does he differ from others, and how?
Well, he sat for it right before the shutdown. And if this had been normal circumstances, he could have continued taking the other parts, but he couldn't. And so because of that, he hasn't had time to take the other 3 parts. Now, he has passed another part. He's got half of them. So, it seems fair to me because there was a 6-month time period that he could not sit for the exam. And I hate for him to lose it because he sat in March, right before the COVID started.
Literally days before.
Days,
It was like
exactly.
March 15th or so when everything shut down, I think.
Qualify for what we did, had to take it after the shutdown.
No, the people that took it, like in 2019, and their parts may have expired later in 2020, they got additional time until September of 2021, but he took it right before. And were we in continuous testing in January and February, or were those blocked?
We were not in continuous testing until July of last year,
Okay.
of 2020, during the pandemic.
We're not going to have anybody in January and February, and that was what I was thinking, that are going to be in a similar situation. He got in at the very beginning of that testing window and then was shut down.
So if he'd taken it a few days later, he would have been covered by our automatic extension. Is that what you're saying?
We base the extensions on expiration dates, not when someone sat. So the extensions that have already been given were based on expiration dates beginning April 1 of 2020 all the way through September 29th of 2021, have been extended till September 30 of 2021. Because he took the exam prior to that and didn't have an expiration during that time period, he didn't fall under the blanket extensions that we've done. Although he was prohibited from sitting for a handful of months there because of the shutdowns and difficulty scheduling.
Okay.
So does his FAR expire March 11 of 22?
He has not passed FAR yet.
I'm sorry, Reg. Like it probably goes to March.
Yes.
Which is what he's asking for now with BEC.
Correct.
Okay.
I was just going to say that we knew that one blanket extension would not cover everyone's situation, and it does seem like this is an extenuating circumstance. I do think it's important to document, if we choose to make an extension, I think it's important to document what we considered so that we treat others equally.
I mean, with what Pam says, it's something we need to do an extension, like we already had the 6 months. Should we consider doing another one just so we don't have, 100 different people fall in that gap? I'm just throwing that out. Because obviously it's lasted a lot longer than anybody expected. Matter of fact, I called a government entity the other day, and they're still remote, which is kind of crazy. But
I think that's, I don't know, can we narrow down what dates we would need to do like a blanket for that? Or
I think at this point we should handle them on a case-by-case basis. If we start to get in a slew of them for a particular reason, then I think we can handle that at that point.
I kind of hated to do another blanket because we went past what NASBA even recommended. And so we may have a handful of people that got it during those first 5 to 6 days of March, but we don't have to deal with January and February because those were those weren't available for testing. Or was it February?
Yeah, January and February would have been
Yeah.
available for testing. The way the windows worked is that third month. So,
okay.
So after March 10th, nobody could test from March 10th to March 31st. It was blacked out then.
T. Mean says, I currently have 2/4 of my credits studying for FAR.
I think he means that he's gotten half of the exam.
And he's studying.
And he's studying for that. So he's on top of it. He just needs a little additional time to protect that first part that he passed. Any other discussion? I mean, I'm kind of hearing some generosity that the committee would be supportive of a 6-month extension for him.
I'll make the motion that we extend for him that 6-month period that he's requested.
We have a second?
I'll second that.
Okay. All right. All those in favor say aye.
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 Any opposed? Okay. We will move on. Thank you. All right. The next one, Mr. Slaughter. This is kind of hard. Mr. Slaughter's father was killed on June 2nd of 2020 in a tragic accident as the victim of being run over by a driver under the influence in a stolen vehicle. The event took place while Mr. Slaughter was actually taking the audit section, and his family was unable to get in touch with him until after he finished the exam. The accident was followed by criminal as well as civil court cases, and he and his family have been required to relive the tragedy. Since the accident, he has suffered anxiety and has attempted to sit for the exam since the death of his father several times, but at times he has been unable to finish the exam due to anxiety that something similar would happen again. Mr. Slaughter originally requested a 6-month extension, citing his anxiety attacks as a deterrent to being able to take the exam. We do have support for the accident details. Court cases, we asked for support related to the doctor's care for his anxiety. Mr. Slaughter responded that at the time he did not have the funds to attend counseling sessions, but had requested access to anti-anxiety medication to assist with dealing with the situation. More recently, I think maybe the beginning of last week, he has requested a 12-month extension as he now realizes that he does need to pursue professional counseling related to the trauma of losing his father, and knows that if he had a 12-month extension, it would minimize his stress of trying to quickly pass the remaining parts. So we're here to consider an extension of time for Mr. Slaughter. Any comments, questions?
I would say we should do whatever he needs. This is probably the most dire, extenuating circumstance we've considered.
Probably
Serious.
PTSD situation, and if he was unable to get help, he's not going to get better until he has the help he needs. So we probably should give him adequate time to do that. I'd be in favor of it as well. Taking the exam triggers him is the bottom line. So until he gets, some psychological counseling, and he's not probably going to be able to see it through the whole thing.
Other thoughts, comments?
Day, as the committee decides, he's asking for a year extension on both reg and audit, which will give different due dates. And so I just wanted to make sure that the committee is clear if they approve an extension, exactly is it 12 months for each one of those, resulting in different expiration dates? Or do you want one expiration date for both?
I think 2 would be less stress for him. Well, of course, unless we gave 12 months from the later one.
So I calculated if the committee were to grant a 1-year extension, I calculated that to be September 30, 2022 for reg and April 18th, 2023 for audit.
I have one question. So he asked for a 6 months extension at the beginning. I'm not downplaying at all. This is just based on how the circumstances fell. He's asking for an additional 6 months because as he started taking it, he realized he wasn't ready and he actually needed counseling. Do we need to require any kind of proof of counseling? Again, don't take it the wrong way. That's just a thought that came in my mind.
I think the less we stay out of the medical aspects, the better. That's just my opinion.
The reason I ask is because we've required certain people to have certain health records to justify their request. So that's the only reason I threw that out there. It's a tough one. I'm not trying to at all. I'm ready to vote for it. I just was trying to be somewhat consistent.
Yeah, I mean, when I read the letter, I thought, well, we do have to have some proof that he's telling the story correctly, and he did include his father's death certificate.
I believe the situation. I believe all that. I just
think that's enough documentation. I don't think that we are qualified to judge how he should recover because time may do the healing. I don't feel qualified to judge, but I'm open to discussion.
I think my thought would be if we decided to give him an extension, I'm not sure that I would ask for any medical support, but if he came back and said, I want more time, I would want to see something where he had been in regular counseling or had regular doctor's visits at that time. But I think right now, I'm not sure that's...
I'm in agreement, Gay. I think that
I do too.
Once this expires, then we... Yeah.
I don't think with this extension, I think we should say we're giving you an extra 6 months because of counseling. I think, I agree with what Gay said, that we're granting a 12-month extension for each part based on the circumstances that happened.
Okay. So what I'm hearing is we would grant him. Now we got to go back and do the 12 months. Is it going to be 12 months for both of them through what did you say? April of 2023 would be the most.
April 18th, we now go by the exact date.
Yeah.
And so I calculated audit to expire April 18th of 2023. So that's the latest date.
Versus the reg would expire on November 30. No. September 30.
September.
Yeah, I have September 30, 2022.
22. On to keep this.
But maybe one date for both parts, and maybe the furthest out date for both parts
Yep.
to give the person as much chance to recover and successfully sit for the exam as possible.
I agree with that.
It gives him about a year and a half from now to pass the other two parts, which might make sense.
And if anyone's confused about the extension on reg, if you're, he received an extension due to the blanket extension due to COVID. So that's, if that's confusing you at all, that's why that time is extra.
Okay, so what I'm hearing is that we would be willing to grant him an extension of those two parts through April 18th, 2023. Is that
Both parts, correct?
both parts?
Okay.
Is that
Yes.
Are you making the
I
motion?
will make that motion.
okay? Second.
I'll second it.
All right, all those in favor of granting Mr. Slaughter an extension of time on his regulations and audit sections through April 18th, 2023, say aye.
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 Any opposed? Okay. We will present that to the full board tomorrow. All right, the last extension request is Ms. Rainey Massey. She was involved in a serious car accident on October 31st, 2020 in Denver and suffered severe head injuries as well as some other physical injuries. Although documentation was not included in your packet, she has provided very thorough medical information, which we chose not to present, from various hospitals, doctors, etc. Since her accident, she was told not to study or sit for the exam so that her brain could heal. On May 26, 2021, Ms. Massey was given permission by her physician to begin studying and sitting for the exam. She is requesting an extension of time that covers the time that she was unable to study as per doctor's orders. She had passed regulations on July 9th, 2020 and BEC on 8/25/2020 in her first sitting, and she scored high grades on both parts. Her 4-month extension request is extremely conservative. I have no problem with giving her this. In fact, Wendy and I talked about it, and I would almost consider giving her 6 months because with a head injury, you don't really know. Some things could pop back up, and those are my 2 cents worth.
I guess as she was conservatively approaching. So, I mean, I would be in favor of even longer. Given the situation, she probably wanted to get a favorable response and maybe was fearful to ask for much. I don't know.
I feel like 6 months would be a reasonable extension. Any other comments? Okay. Well, with no other comments, I would make a motion that we provide her a 6-month extension. until June 30, 2022, for her sections regulation and BEC.
So they expire at different times, so you want to extend them both till June 30, 2022, correct?
When do they expire? I can't. When do these expire?
I calculated reg expiring 12/12 of 21 and BEC at January 27th of 2022. So I just want to be clear that I write it down correctly.
Yeah. And she only requested an extension through April 30 of 2022, and I just tacked on 2 more months.
Okay, that's fine. So an extension until June 30, 2022 for both reg and BEC. I got it.
Got it? Okay. Do
I'll
we have a
second
second?
it.
You'll second it? Okay. All those in favor of this extension through June 30, 2022, say aye.
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 Any opposed? Okay. The last item on our agenda is an accounting course at MTSU, accounting course 3000. The department chair has requested that we accept accounting 3000 as a lower division accounting course. We were provided background information from the department chair, including course information, materials, description of assignments, and the course schedule. This course is geared towards non-accounting majors. However, I did look on their undergraduate catalog for the 21-22 year, academic year, and it did say that you could take this class as well as accounting principles or accounting 21-25, which is accounting principles number 2, and with the qualifying grades, you could move on to intermediate accounting 1. So we're not being asked to accept this as upper division accounting class, but strictly as a lower division. Sherry has taught this class in the past. Is that right? Okay. And you have looked at the current textbook. So what are your thoughts?
Well, basically, as I spoke to Wendy, and this was, I think the last time I could, looking back in my records, it was like fall of 2013. So keep that in mind. There's been a few years. There has been a textbook change since then, too. And I do know that I'm familiar with this particular textbook, and it is a little bit more geared towards accountants rather than business. Basically, how this course was designed, when I was teaching it, the vast majority of the population in the classroom were either in the aerospace program at MTSU and wanting an accounting degree, or they were in the music business discipline at MTSU. So vast majority of the students fell into those categories. Basically, what it tried to do was take Principles 1 and Principles 2 and combine them into one class. So obviously at that point in time when that happened, you covered a lot of material in a semester that you would normally take 2 semesters to cover. So when I taught the class, it was more of an overview. When I say that, you get all the basic knowledge, but say you're not going to learn journal entries, or I didn't attempt to teach journal entries when I taught this course. I taught high level. We would learn depreciation methods, but we wouldn't necessarily spend a lot of time doing calculations of depreciation methods. Same thing with LIFO, FIFO, weighted average. We would understand the concepts, but not spend the in-depth time that maybe you would do in a principles class, because you were trying to combine the two. Now, what you're telling me is that in the current catalog, that they are taking this particular course along with Principles 2 to allow students to move on to intermediate. So what that tells me intuitively is that they're spending much more time, and the syllabus reflects this too, on the Principles 1 area and just barely touching budgets and managerial accounting in Principles from the Principles 2 book. So to me, the class has changed a little bit, and to my guess is there's much more of an emphasis on some of those areas that we kind of lightly touched when I taught it previously. My bottom line to Wendy was that I have no problem, based on my experience, of this being an elementary course. Because it's a 3,000 level, if somebody tried to ask for upper division, I would not be supportive of that. But for elementary, which they're requesting, I think that's reasonable.
And she is only asking for 3 hours credit. We're not trying to combine accounting's principle 1 and 2 into one course. So, any thoughts?
I have thoughts. I'm very familiar with courses like this, like Sherry. I don't think for our decision it matters how they're splitting financial and managerial accounting. I think there's no doubt that this is accounting principles, and I sent Wendy a description of the textbook that specifically says it teaches the principles of financial and managerial accounting. That's in the book description. But I was already familiar with the book. I knew that was the case. Sherry's right. Out of 13 modules, 11 are financial, 2 are managerial. I don't know if you noticed, a person had asked NASBA to count this as principles, and that person had taken this and then a 3,000 level managerial course. So at first I thought, well, maybe they were thinking she was double dipping and covering the same thing twice. But no, this is just an introduction. So I am curious as to why NASBA didn't allow this. The only thing I saw was that it's numbered as a 3,000 course. And I'm thinking that may be because the graduate students take it. It wouldn't count toward their master's program, but I'm surprised it's a 3,000 level course. But I'm curious as to why NASBA would deny this. Do you have any idea, Wendy?
I think that they're going on the basis that this board has not accepted courses that were not intended for accounting students or have the survey type title to them, where there are non-accounting majors taking the course. And so I'm guessing that's their reason for not accepting it.
And you and I talked about that. Each school covers these things differently, and we've gone through periods where teaching journal entries was just not done in principles at a lot of schools, and yet that was the course people took, even if they were going into accounting. And so I think we've got to stay away from telling schools how to teach the courses. This textbook is a financial principles textbook. I am absolutely certain it's used in many, many schools for the accounting majors course. I don't think that I hope that we back away from trying to dictate which principles course somebody takes, because to me, whatever they get at principles, they then validate in later courses. So I think it's very important to note that MTSU says this is good enough to be the entry to their intermediate course, and therefore I think there's no doubt that it's accounting principles.
I appreciate that, Pam. We actually have another case that came in just maybe Friday, a course at University of Mississippi. It looks to be a very similar situation where the course is more of an intro survey type course, and NASBA's asking if we will count it. I asked for some additional information, so I didn't have time to put that together and bring to you all. But I appreciate that input and any other discussion on how to treat these types of courses.
This is Janet. My daughter actually took this course at MTSU. She was a music business singer-songwriter major, also a minor in entrepreneurship. And I taught not this course, but a different principles course. and to my recollection, they did seem pretty similar. So, just a comment.
Thank you. Any other? So what I'm hearing is that we would be willing to accept this course as a lower division accounting course given 3 hours of credit. Do we have I guess that's my motion. Do we have a second?
Second.
I'll second.
Any discussion? All right, all those in favor of accepting accounting 3000 as in the lower division accounting course with 3 hours of credit, say aye.
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 Any opposed? Okay, Mr. Chairman, that is it for the licensing committee.
Hey, thank you to you and all of the members of the licensing committee for your diligent efforts, and also for just exhibiting, I think, the empathy and compassion that folks that are aspiring to enter the profession need. And so appreciate that, and also the richness of resources we have in the form of Sherry with respect to teaching, as well certainly as Pam. And Janet, I didn't realize you'd also taught a course similar to this as well. So we're blessed with folks who know what they're talking about, which is always a good thing. So thank you. I think we're ready to go to the Enforcement Committee. What I would propose to the board that are present and also on the phone is that we'll go ahead and deal with the Enforcement Committee agenda items and then take a brief break after that before we head into the stretch for the last two committee reports, if folks are comfortable with that. Okay, Andy, I'll turn it over to you.
Okay, thank you, Mr. Chairman.
Andy, sorry, can you pull your microphone towards you?
Yeah, there we go. How's that?
Perfect.
We're going to start with the open complaint file, just a case and complaint report, and just go through it and ask if Sherry or Maria have any statements they want to talk about. First of all, those are the open complaint files, but not the ones presented today. It looks like we have one that staff response is requested, and then we have one that legal's working on. As far as CPAs, when you come down, we've got a yellow item there that Sherry is investigating. And then we've got two that are under payment plans, and then we've got two that we're just monitoring the litigation. As far as CPA firms, it looks like that we've got legal is reviewing the cases on 3 of those. We've got one that Sherry is investigating, and then also we have one that has a legal closed payment plan. One of the more interesting numbers below is for fiscal year 21, we have 48 complaints. Our complaints were almost half of what they have been in prior years. And you can see that it goes for fiscal year 2020, 93, 19, 95, 18, 86, and 17, 97. So I think COVID probably had a little bit to do with that. But with everything going on, it probably was a good thing. Any questions about that report? If not, we'll present that tomorrow to the board. Everybody also received a legal report, and in that legal report, there was a synopsis of the legal report. There was, and I'm going to start with it and kind of talk about 2 cases that we had that were consented or proposed to close. And on those 2 cases, it was investigated for the 2 complaints, and there was insufficient evidence on both of those to support the allegations. So I would ask for a motion to close those 2 cases.
So moved.
In a second. We got Janet.
Second.
Was that a second?
Yes, this is Janet.
Okay. So I guess I've got to have a call vote since there's just 2 of us here and 2 on the phone, or because Janet and Pam are on the phone for it to.
I think so.
Andy Bonner,
Aye.
Janet Booker Davis,
Aye.
Pamela Church,
Aye.
Greg Gilbert.
Aye.
Okay. Thank you. Now we're going to go through, we've got 4 with, or I guess, really let's see, we've got 6 under proposed discipline. And
okay, hold on one time. Sorry,
Andy, do you have number 3 on there under the consent agenda as well?
I just have 1 and 2 on the legal synopsis. Let me go back over here and look on the legal report.
Are you
itself.
looking on the iPad or on your device?
No, I'm not. I guess it's been updated.
Yes, I'm sorry. We received information subsequent to me sending out that initial report on this particular licensee, and so it has been updated in a short period of time.
Let me just clarify. Everyone else should have the correct. Just Andy sees it in advance of everybody else. So I think what he is referring to was the advance document that he saw. You think that's correct, Andy?
That is true. I thought that I had actually gotten. Of course, last week I was in NASBA board meeting, so I think something must have overrode when I copied it all down.
Okay, so what I've sent to the rest of the board members on Wednesday should be accurate, because that's what I have in front of me. So you should have 3. Everyone else should have 3 cases under the consent agenda.
Okay. So let's go back and look at the third one under the close. My apologies. So I've got the other pad here, and so it was. It says here, due to the continued decline in the health, the respondent determined that the completion of the required CPE to maintain a license was not practical at this time. Respondent has since closed her license, so the recommendation is to close. So I would ask for a motion on that.
So move.
And a second.
Second.
All right. Now the call vote.
Andy Bonner,
Aye.
Janet Booker Davis,
Aye.
Pamela Church,
Aye.
Greg Gilbert,
Aye.
Okay.
Andy, sorry, I hate to interrupt you. I just wanted to say one more thing.
Yes, ma'am.
For number 4 that we're about to go to, we also have new information as of this morning. The respondent has sent in his required paperwork and everything, and his license is for reinstatement. So that is the new information that we can add to number 4.
Okay. So we're gonna go to number 4. On number 4, the firm was dropped from the ICP peer review program for non-cooperation on October 7th, 2020. After further review of the matter, it was discovered the respondent firm permit had been expired status since December 31st, 2019. Respondent had completed both the 2019 and 2020 audits for a client after the firm permit had expired. A complaint was opened by the board to review the matter. A response was not received from the respondent after 2 attempts. Investigator was unable to contact the respondent through an alternate email address. And however, notification was found with an alternate email. And so we were able to get in touch with him, and obviously now with him reapplying, we've gotten some response, and he's talking to us. He was unaware of his firm had been dropped from the peer review program. His individual license had expired December 31st, 2020. The recommendation here is authorize a formal hearing, and make sure the recommendation hadn't changed. Yeah, formal hearing with authority to settle via consent. All right, guys, no insurance talk on people. Okay. Somebody say something? Okay. Upon the respondent's payment of civil penalty in the amount of $2,250 for the following violations. $1,500 for 2 counts of issuing an attest report for the 2019 and 2020 audits for the client without an active firm permit, and $750 for 1 count of issuing an attest report for the 2020 audit for the client without enrollment in an approved peer review program in violation of board rule. And this morning he reapplied.
Yes, we received his application to reinstate his firm, which we processed this morning.
All right. Any questions?
I make just a statement or a request of this committee. As we go through each one of these, I'd like for the committee to consider making sure we're consistent on which ones we're requiring to do the NASBA ethics course on and which ones we're not. Because in some cases, it seems like to me that if there's a violation, they ought to automatically be required to do the NASBA ethics course. But we're doing it on some, or the recommendation is to do it on some and not others. So I'd like for the committee as they go through this to make sure we're being consistent on that. Just a request, not on the committee.
Excellent question. The last thing out without civil penalties is to send a letter of instruction regarding the violation and inform the board if they had just changed within 30 days. So that's also included there.
I'm not sure what you said means. So he's applied. Does that mean he's now in compliance with?
Correct. So we received the case indicates that he issued a test reports without an active firm permit. It had expired. Well, we received a reinstatement application, I think on Friday, and we processed and approved it this morning. So he has an active permit as we speak today. Does it help answer your question?
Right, but he's still in violation. He issued these reports.
Yes.
Without peer review compliance.
Correct.
And
yeah.
They've entered into the peer review program, or they?
Yes, that was correct. I mean, basically, this was kind of a funny one, and it started out just being notified from the AICPA that the firm was dropped from peer review. Since we could not contact him, I basically did an internet review to try to find an alternate contact for the firm and found the alternate contact via 2 audit reports that were out there. And the 2019 audit had been submitted after the firm permit had expired, but he was still enrolled in peer review. The 2020 audit for the same client was submitted after, again, the firm permit was expired, and at that point he had been dropped from peer review. So that's why there's an inconsistency where there's 2 counts for lack of licensure and just 1 count for peer review. At this juncture, he has renewed the individual license, re-enrolled in peer review, and just this morning reinstated the firm permit. So it's active in core right now.
Questions? Case, and we'll take all of these with the recommended recommendations at the end. So we'll cover them all then. Let's go to case number 5. And I think, were there any other cases that actually changed without me having to go? I didn't realize that, and I apologize. It was just that first one.
Yes, and also we added on number 7,
okay.
We added just like an alternate option for discipline. So
okay,
but it's in addition to and not in lieu of. So.
Okay, all right, thank you. Case number 5. The respondent provided 2 compilation reports to the Board of Contractors dated February the 4th, 2021. As of the date of the reports, the respondent's firm permit was expired grace status, and the firm was not enrolled in peer review. The respondent had a peer review exemption form on file with the board. A client base was acquired from another CPA firm in 2020. Some of the new clients required a test services for Board of Contractor License applications, so the firm later enrolled in peer review. It should be noted, however, that the firm did not enroll in peer review until after the complaint was filed. The investigator inquired if a test reports have been issued for clients not referenced in the complaint report. The respondent stated that the 2 attest reports referenced in the complaint are the only reports issued to date. In regard to the expired firm permit, she had renewed the firm permit in core but never received confirmation of renewal. The respondent did attempt to renew the firm permit in March of 2021. The firm permit application was on hold because the respondent had not renewed her individual license. The recommendation is to authorize a formal hearing with the authority to settle via consent order upon the respondent's payment of civil penalty in the amount of $3,500 for the following violations.
Sorry, Andy, that's not the right. Yeah.
Okay.
It's 1,500.
It's 1,500. Okay, so that one was updated too. My apologies. I guess I'll just read from this one then. Authorize a formal hearing with the authority to settle via consent order upon the respondent's payment of civil penalty in the amount of $1,500 for 2 counts of issuing an attest report without an active firm permit in violation of TCA 62.1-108A. Require respondent to complete a peer review by February 28, 2022. Any questions on that one?
Does it mean where it says the respondent had a peer review exemption form on file?
Wendy, you can correct me if I'm wrong, but whenever the firm permit application, if you're not going to do a test work, then you sign a form saying that you're exempt from.
Any other questions? All right. We'll go to number 6. On number 6, the respondent provided financial statements and a review report dated December 14, 2020 to a client for inclusion in their license application. The respondent was properly licensed but not enrolled in an approved peer review program at the time the report was issued. Accordingly, the board opened a complaint against the respondent. The respondent did not deny issuing the review financial statements. The respondent had intended on enrolling in peer review, but was sidetracked when her brother passed away unexpectedly. After further reviewing the matter, the investigator found the respondent had provided a false statement on the firm's renewal application dated December 31st, 2020. The respondent stated that the firm was not providing attest services. Evidence supports the issuance of at least one attest engagement on December 14, 2020. It's recommended that authorize a formal hearing with authority to settle via consent order upon the respondent's payment of civil penalty in the amount of $2,000 for the following violations: $1,000 for issuing an attest report without enrollment in an approved peer review program, and also $1,000 for providing false information on a renewal application. Any questions on that one? And that's number 6.
I was just wondering, this is Janet.
Okay.
What's the basis of the $1,000 for providing the false statement?
Hi, Janet. This is Maria. I got that off of the discipline matrix that the board references. I've not had a violation like this since I've been with the board, but that's a standard penalty for providing the false information on the application. And I didn't do any mitigating factors in this instance because I didn't have any to support that. So $1,000 is just a standard penalty for that violation.
Oh, okay, thanks.
Any other questions?
I think the last part, Andy, there might be important. Require the respondent to provide an exemption form agreeing to complete no additional test work or provide proof of enrollment in peer review and the completion of a peer review by February 28th, 2022.
There's no questions any further. We'll go to back up on me. Okay, to this one. All right. Now number 7. Complainant states that the respondent removed confidential client records from the company without their permission. The informant was subsequently used in litigation. The information was subsequently used in litigation against the company and in advertisements in local newspapers in an attempt to discredit the company and its board of directors. The complainant also alleges other ethical violations of the respondent, including violations of the board's integrity and objectivity rule for acting through others and inappropriate use of CPA designation.
Yes, I have a question.
Does someone on the phone have a question?
If you're on the phone with us, be sure and punch mute if you can. We appreciate it. Thank you. The respondent filed complaints against her former employer in federal court for sexual discrimination and wrongful discharge using confidential company information to support her claims. The district court ruled in favor of the respondent's former employer. However, the respondent has appealed to the district court decision and will likely provide additional information to assist the board in assessing allegations made in the complaint. The respondent states that other ethical violations alleged in the complaint are not applicable because she never acted as a CPA in her role with her employer. The respondent also believes that the inactive status of her license limits the jurisdiction of the board as over her license. It was discovered that the respondent was terminated after making a request for a salary increase. When the respondent was denied when the request was denied, the respondent provided her employer with a list of questionable business decisions made by management over her 30-year tenure and brought charges of sexual harassment against the supervisor. She was placed on administrative leave while an internal investigation was completed. While on administrative leave, her employer discovered that she had removed company information from her work computer and server and requested assistance to coworkers in obtaining additional company information. At the time her employment was terminated, the respondent never reported any of these allegations against management to legal or regulatory authorities. It was determined the respondent had disclosed company information to the public in three different local newspapers through advertisements she had purchased to disparage her former employer and the company's board members. The information contained in the advertisements could not be obtained through public sources like the company's website or annual reports. It was obtained solely in her role as the Director of Accounting Finance for the company. The respondent also provided copies of company documents to individual third parties on flash drives for safekeeping during the litigation and enlisted the assistance of her ex-husband in scanning company documents to forward to her attorneys during the litigation process. That evidence shows that the respondent approached two coworkers asking them to provide documents she could not access in support of her litigation. One coworker was subordinate. This supports allegations of acting through others to commit an act discreditable. The recommendation here is to authorize a formal hearing with the authority to settle via consent order, granting the respondent 30 days to return all confidential client records of the complainant, subject to approval and satisfaction of the board's executive director. As part of the consent order, a provision for automatic suspension of respondent's license in the event that she does not comply with the return of records within 30 days until such time as returned, will require the respondent to pay a civil penalty in the amount of $4,500 for the following violations: $3,500 for 7 counts of violating TCA 62.1.116 for acts of discreditable, and also Board Rule 20-03.12, and $1,000 for 2 counts of violating Board Rule 20-03.13, acting through others. Require respondent to complete the 3-part NASPA ethics course within 30 days. As an alternative to paying the $4,500 civil penalty, respondent may agree to voluntarily close her license. send a letter of instruction regarding violation of Board Rule 20-05.03 for use of CPA designation without the inactive qualifier. Any questions?
This is Janet. I was wondering the court that ruled in favor of the employer, did that the court's finding require that those confidential documents be returned?
Janet, this is Sherry. No, they did not address that issue. They strictly looked at the sexual harassment claim and the wrongful discharge claim, but they never addressed the return of records. That was probably what precipitated the complainant to file the complaint, is to look at the confidential records. But the court, it was in federal court, they did not address that issue.
I guess that I'm wondering, would we be overstepping our bounds? Not that it's unreasonable to want to require this action, but I guess I'm thinking we should be consistent with what a court would impose.
Janet, this is Maria.
I'm consistent with the court, but...
So sorry. This is Maria, Janet. That's a good question, and this is something I discussed a good bit with my supervisor, Tony, because I had the same question. However, so in this case, the complainant would be the defendant in the federal court case, and they never requested, or their prayer for relief was not centered on the return of the documents. And so it's not an issue that was heard by the court. And we do have the authority in this case to discipline, and issue the civil penalty in the event that the documents are not returned. So we're comfortable moving forward at this point. And I don't believe that it is, going to interfere with the current case or the appeal.
So you're saying our basis for these penalty fines is because the documents weren't returned?
I'll address that. This is Sherry. The basis for that is actually the Code of Conduct would permit her to use confidential employee information to support a legal claim. But where the counts come into effect is during and after the litigation, newspaper advertisements were purchased in local papers to publish confidential company information to disparage the employer while this was happening. And that is the focus of where we are looking at this in terms of confidential records and the, misuse of, if that makes any sense at all.
I guess I hear what you're saying. I don't know that I'd be comfortable in kind of getting involved in this kind of thing. That's just me. But
Janet, thank you. And I just want to mention that this is a more complicated complaint, and it's not something we routinely have dealt with. So I am open to suggestions. This is your discretion, and so I am open to any suggestions that you all may have. I took what the violation was in the discipline matrix and kind of went off of that. However, like I said, I'm open to suggestions. Also, I did speak with Kevin about this, and because this respondent's license is currently in inactive status, and it has been since 1996, I believe, an alternative in issuing the civil penalty, the respondent could agree to close her license and forego the civil penalty. We would still require the return of the records, but that was, an option that we kind of thought would protect the public while also dealing with the matter that we have before us.
The respondent has this out in the district court waiting on an appeal decision. Is that correct?
The respondent has appealed the decision. Yes.
Okay, and then that hasn't been resolved yet. Is that right?
That's currently pending.
I guess I would think we might want to wait to see how the appeal comes out. Would be the only other comment I would have. And maybe if they agree to close the license. But I don't know. It just seems like it's kind of straying from. I don't know.
Certainly. And Janet, just to reiterate, the appeal is focused on the sexual harassment claims, and so it's not related to the records issue. So I don't know if waiting for the appeal court's decision would have much bearing on what the board decides to do. I don't believe it would have any.
Okay, okay, I guess I see what you're saying. I don't know. It just seems like we've kind of strayed from the issue of the case. Then, so anyway, that's my comments.
Not being on this committee, but just curious as to how. I mean, I can see where we would require records to be returned, but there's no way to make sure that those haven't been duplicated or they're on another hard drive or they're. I mean, I guess I don't see what's accomplished by that unless it's like a discovery thing to see what the person has that belongs, the information the person has that belongs to the company. I don't really. I mean, they're probably going to have copies, hard copies, electronic copies, whatever. I don't see how we can make sure that they literally get rid of everything.
I think that's a good point. I think one of the main reasons we focused on it at all, Judy, is that the complainant requested that action from the board. So that's why we focused on that at all, was that in the complainant did request that action.
How can this board make sure that happens? I don't.
Excellent point.
Would it be appropriate to get a signed statement that they have returned all copies and documents were kept anywhere?
Yes, and I put the recommendation rather broad so that that the return of the records was satisfactory to the approval of the board's executive director. So I just thought that maybe it'd be something that you all could delegate that authority to Wendy, and Wendy and I could all work in conjunction with the complainant to make sure that was up to the satisfaction of, what we thought would be a good standard for return of records. But Judy, you're right. We can't, especially if these things have been downloaded to hard drives and that type of thing, we can't guarantee that. But if there are flash drives and hard copies, we can ensure those are returned. And a matter of principle, they should be, because this is, an egregious act.
And I don't disagree with that at all. I just think in this day and time with the availability of all that, I don't think the complainant is really going to get 100% of what they're asking for. But we can certainly do our part to try to make that happen. That's all
Well, the penalties are for specific acts, specific violations, and they would be assessable really whether the client returns, whether the defendant returns the records or not, correct? Yeah.
Like I said, if that seems too complicated or maybe moot at this point, especially in this day and age of technology, I'm open to suggestions on how you all would like to, proceed in discipline.
Well, I personally, I would think the best we could absolutely do is have the defendant to sign some sort of document that the complainant comes up with, acknowledging that they have given everything to their satisfaction. I'm not so sure it should be us that I mean, we're kind of facilitating the.
Well, I don't want to say that as much just because we are issuing the discipline. So I'm comfortable drafting an affidavit that the respondent would have to sign in this case, attesting to the return of the records.
I would agree with that. And then, then the three of y'all work together and leave that statement in to the satisfaction of the executive director. And it seems like the other question we have down here is whether instead of assessing the civil penalty of $4,500, it would be if she were to respond with closing her license, that we would waive that. Do y'all feel like we should assess the penalty period?
This is Kevin. This was one of the issues that I had discussed with Maria when I was reviewing the proposed discipline report. And, she has an inactive license and has stated effectively that she doesn't think she's subject to the board's jurisdiction because she has an inactive license, which is not factually true. And so, one of the objectives here was to try to basically encourage her to no longer hold oneself out as a CPA. So there were kind of two provisions here. One is if she's willing to close her license to forego the penalty. The other issue was to suspend her license automatically until such time as she complies with the requirement to return the relevant records. In either case, her license, she would not be a practicing CPA. And that was kind of the thought process that went through providing that option, along with the notion of the complexities of any future hearing that would likely take place if this moved forward.
The thing I would add to that, which I think might be important for the board to know, is that this individual is at a position where she's probably at the end of her career. So I don't know if that is of relevance or not, but I think it's important to know that.
Is there something in the documentation in the case that says the complainant requested that the board asked the respondent to return the records, or did I miss that?
Yes, that was in the complaint, Janet.
It's in the document. Where is that? That's in the documentation that we have.
Oh, I'm sorry. It's not. I don't know if it's in the summary, but it is in the one of the 800 pages of documents that we received for this case. Yeah. Also, I just have to give a plug to Sherry because she really did a great job on this report and investigation.
Can I clarify something quickly? So we talk about suspending her license if she does not comply with the return of the records within 30 days. But we can't do that unless she signs the consent order agreeing to return the records, correct?
I believe so.
Okay, so if she gets this consent order, whatever's the board decides is the parameters, unless she signs it, nothing happens until she signs it or we go to hearing, correct? Okay. And my final question is, we have this, an alternative to paying the $4,500, respondent may agree to voluntarily close the license. If that's the direction she decides to go, would we still require the NASBA course? I'm guessing no, but we might want to clarify that.
I can add language that as an alternative to paying the civil penalty and the completion of the ethics course. I'll add that in there as an amendment.
Any other questions? All right. And that's number 7. So as we go through to approve all of the cases at one time, we'll note the fact that number 7 has been amended, subject to Maria's statements on closing the license for relief of the $4,500 and also the NASPA part. And then also the if she doesn't sign it, it would then go to with the letter of the consent to return everything, then it would come back for a hearing. Any other questions on that then? All right, well, let's go to number 8. It says here the board received notification the respondent entered a guilty plea to one felony count of use of tax evasion after an investigation of the Tennessee Department of Revenue. The respondent was required to remit the unpaid use tax and was sentenced to 1 year on unsupervised probation. A complaint was opened to explore the matter further. The charge was brought when the respondent failed to properly report the accurate purchase price of a houseboat. He takes full responsibility for his actions and regrets the decision he made. He also explains that the charge was placed on judicial diversion and a conviction of crime was not entered against him. After reviewing the investigation report provided by Tidor, the special investigations team, it was determined that the respondent closed on the purchase of a houseboat in May of 2017. However, he did not register the boat or pay use tax until June of 2018. At the time, he intentionally reported significantly lower purchase price to reduce the use tax liability. He reported a purchase price of $15,000 when the actual purchase price was $146,000. At the time of registration, the respondent provided an altered and fraudulent bill of sale to support the declared price of $15,000. A complaint was filed against both the individual license and the firm permit of the respondent. While the matter involves a personal purchase, it does not involve the respondent's firm. The firm's permit status may be impacted depending on the discipline required for the respondents in this matter. The recommendation is for suspend respondent's license and firm permit through December 31st, 2022, in order to require respondent to appear before the board if reinstatement is pursued. Require respondent to pay $2,000 civil penalty in violation of board rule number 20-04-032B and board rule 20-43.032E. Require respondent to complete the 3-part NASBA ethics course prior to December 31st, 2022. Any questions on that one?
This is Janet. Just a point of clarification. The respondent is the majority interest partner in the partnership?
That is correct, Janet.
Okay.
Wendy, I think I've asked this before, but will you remind us the NASBA 3-part ethics course? How many hours is that? Do you know?
I honestly don't know. We 6 to 8 hours, and it's not state specific. It's more based on just general ethics, and I think there's some code of conduct information in there as well.
Can I ask some? This is Janet. A question on the state specific, or I guess the NASBA ethics course. Does it cover, either one cover the requirements for doing a test work? And I guess I was looking back at these cases where there's been I think it was the earlier cases where there's a violation for not having peer review or enrollment, where they know about these rules.
Yeah, the state ethics course covers it in great detail because of these issues. The NASBA the NASBA course is not state specific, so it's not going to specifically cover that.
Okay, so I guess to Larry's point earlier, where they have these violations, I guess I'm thinking we should require them to take the state-specific ethics course as part of the recommendation.
In most cases, they've already taken it. They just must have missed something along the way.
Just forgot that part. Oh, well, maybe they need to take it again then.
Maybe.
And I will say earlier, to address Larry, your point earlier, and Janet, your point about when we're assigning these, requirements for or recommending for the ethics course. Sherry and I and Wendy, we all kind of use our discretion in looking and seeing, is this a mistake? Just like earlier, the one gentleman, he didn't have his enrollment in peer review or his firm, but he wasn't getting notifications. It seemed like a administrative or just kind of a error. Not that he didn't know, but like Wendy said, maybe he just didn't do it. And so rather than them just not having the knowledge or needing, education, in this case, fraudulent documents and that kind of thing, we thought it was a more appropriate situation to require the ethics course. So we kind of look at what's going on and then use our judgment in whether or not we're going to require it or recommend requiring it.
I recognize, I agree with Janet's point that a lot of these have to do with the state-specific topics. But the one that raised my question the most, and I realize, Mr. Chairman, that you're going to readdress these as we go through, but there was one over here where the guy provided false information on a renewal application. I mean, that's just ethics in general. But we didn't suggest any ethics on that one. But that was just one example. But yeah, Janet makes a good point that if it's a violation of a Tennessee-specific law, then the NASBA course is not going to help them. But they're going to take that every 2 years, the state-specific course anyway. Like Wendy says, they either were absent that day or they weren't paying attention. So I was just suggesting that we look at each one as we go through. Apply to all of them.
Any other questions about any of the proposed disciplines? We've got 5 cases in front of us, and what we'll do at this point is ask for a motion to accept the amended recommendations from council. And I guess that I think you bring up a pretty good point there, Larry, that should we go back and consider that one for maybe an ethics course?
Yeah, that was for case number 6, I think. I think that was the one, Larry, you were pointing out that would potentially be in need of a NASBA ethics course recommendation given the notion of providing false information on a renewal application.
Well, even in that case, in that case, you could just say that's just pure honesty versus dishonesty. An ethics course that NASBA provides doesn't really say always be honest. That's just a general statement of life, try to be honest. So I'm not saying that particular one, that a course would help in that case. My suggestion was, and not necessarily with these cases, but going forward, I think we should make an effort, and I think you do. It was just a reminder that in some of these, I noticed that we were suggesting the NASBA course, and others we weren't. Some of them were borderline. I was just trying to suggest consistency. So,
now, I believe that was case 8, wasn't it? I'm getting confused between my 2 places here.
Case 8 is the one we just discussed.
Okay.
And case 6 is the one where there was false information provided on a renewal.
Okay, I'm with you.
But you're right. 8 is a fraud situation. Yeah.
Yep.
And that was kind of my reasoning. Sorry. Go ahead, Janet.
Oh, I guess I was just thinking in general, and I don't know that we don't do this, maybe we do, but I'm sure it's a requirement that licensees are supposed to keep their address current with the board. and they're supposed to have to, do we instruct them to review the rule as part of I guess settling their penalties or whatever?
So,
I mean, that in the recommendation it refers to the rule, but do they have to go back and at least review the rule where they're in violation of it?
for the address issue, I recommended a letter of instruction, and in that letter of instruction, I set forth the statute and rule that they are in violation of. And so the language of that letter says, the board seeks to remind you that, TCA so-and-so says this about keeping your address up to date with the board.
Okay, so you do kind of educate them on the rule and how they're in violation. So
yes.
Okay, that's good.
Mr. Chairman?
Yes.
I suggest that move that we accept the legal and staff recommendations for cases 4 through 8, subject to the amendments we discussed for case number 7.
All right. Do I have a second?
I'll second.
All righty. Roll call.
Andy Bonner.
Aye.
Janet Booker Davis.
Aye.
Pamela Church.
Pam, we can't hear you if you responded.
Maybe she dropped off. She said she had a spotty connection.
Greg Gilbert.
Aye.
Okay. We've got 3 re-representations here. In this case, I'll just go back and add the new information we have and then the recommendation from there. Number 9, the first one is the case was heard on April 19, 2021. The respondent pleaded guilty to theft of property between $60,000 and $250,000, a felony. The respondent was sentenced to 10 years with a period of incarceration of 9 months. The remainder of the sentence will be completed on supervised probation. One of the conditions of supervised probation is that the respondent will work in a lawful occupation, support her dependents, if any, to the best of her ability. The respondent is currently incarcerated and never responded to inquiries by the board regarding the complaint. Authorize a formal hearing with the authority to settle via consent order for voluntary revocation of the violation of Tennessee or TCA 621-11188. Any questions on that one? Okay. Number 10, it says here that legal has not been able to contact the respondent. Additionally, the complainant is no longer responsive to legal counsel. Without the cooperation of the complainant, the board attorney will not be able to take this matter to hearing successfully. The recommendation here is to close and flag. Questions on that one? And number 11, it says here the new information is the response license was voluntarily closed in December 2020. The only requirement for respondent is to appear before the board prior to reinstatement of the license. It says that under the rules, respondent is able to pay the fee, show CPE compliance, and then be reinstated without appearance since his license was not suspended. The agreement has the respondent has expressed numerous times that he will not be pursuing a career as a CPA. He has agreed to appear before the board if he chooses to reinstate his license. However, there are pending appeals, lawsuits concerning the termination of employment and the validity of the SEC order. Respondent has filed a malpractice lawsuit against his former legal counsel, stating that the SEC suspension was negotiation advised to him by a law firm he is now suing for an ethical breach of re-representation, breaching its duties to him as a client because he alleges he also represented his employer. In doing so, the firm took actions on behalf of his employer against his own interest. He alleges that the information obtaining for an internal investigation and the agreement for suspension profited by his represented counsel were due without his informed consent. Though they were representing him, the case has been remanded back, to the trial court, which may not hear this matter for quite a while. So it looks like we have a lot of different legal issues here in this case. I know that you had said that it was really too much to type, but it looks like you went back and typed some here. Go ahead.
Yes, my name's Stuart Huffman. I'm the previous disciplinary counsel for this board. I had to go back and type a little bit of information because it's a very complex issue. There's a lot of legal questions about this, so I just wanted to put as much as I could in there for you all's review. If you got any questions, of course, I'm here to try to answer.
I have one. I think the recommendation that making here, closing flag, and all this gets settled, he comes back in for reinstatement. Do we still have the option at that point to start an investigation of our own, or do we have to go along with whatever happened?
Well, it depends on what happens in this case, obviously. But
it sounds like he might be able to come back and all he had to do was catch his CPE up.
At this point, what would happen is a closing flag feature. It would flag his file so that if he tried to come in and reinstate his license, then we would stop that and he would have to appear before the board.
What options do we have at that point is what I'm asking. If he comes in and just says, I want to do 80 hours of CPE and get my license back, can we say, okay, we'd like to look further into this before we grant that? Because we're basically saying we're going to turn this over to the courts at this point, aren't we? And we're saying,
well, yes, you would have that discretion in order. I mean, you would be able to talk to the respondent and question the respondent, and if you felt like there was more information that needed to be had, then you could vote to reopen a complaint. At that point. Yes, I would. Yes.
Stuart, would they be required to issue the license and then look into it, or would they be allowed to hold on reinstating the license?
That's a question I cannot answer right now. Either way, I mean, I believe the board would be able to reopen a complaint whether or not the license was issued or not.
Can I add something here? There is an SEC sanction here. The SEC suspended him. So could the board not, and I'm asking a question, could the board point to that SEC sanction if it's not remanded? You know, I understand that there could be some efforts here to reverse that SEC decision. But if the decision was not reversed, could the board not use that as a objection to possibly reinstating his license?
If that decision is not remanded, then of course it's still out there, and there is a rule for the board that has that discretion to issue disciplinary counsel or issue disciplinary action because of the state or federal agency issuing an action. So yes, it still would be out there. Now, if it was remanded and considered null and void, then there's nothing out there for the board to consider.
Will we not be in a better position if we just continued this one and waited to see what happens in that case?
At this point, it's a recommendation that this case could go for 3 or 4 more years. It could go for numerous years. We don't know. I mean, it's been going on for a long time. I know COVID kind of got in the way, but this case could go on and on. At this point, the previous recommendation was to suspend till the end of 2020 and then also have the respondent agree to appear before the board. Now that suspension is past 2020, what the board is now asking is to appear before the board. So that closing flag feature would give what the board is actually requiring them to do.
So he has agreed to appear before this board before he asked for a reinstatement.
He's
Do
yes,
we have that in writing, or
that's the problem, is that with all the appeals and everything going on, his attorneys that represent him now and himself really don't want to put anything in writing that is stating that because of this order that's out there that I'm challenging the validity. Doesn't want to put that in writing, because then what he's doing, he's counteracting himself. So that's the issue that we're having, is nothing can be put in writing according to his current legal counsel. And that's why we have that closing flag feature.
It sounds like he's asserting that he's not going to be attempting to reinstate his license, but that if he does, because of the close and flag maneuver that we have in place, before he could, the board wouldn't be in a position to take action.
Yes, that's correct. That's correct. And he's stated numerous times that he is not considering going back into being a CPA. He's actually passed the bar and is under the jurisdiction of Washington, D.C. as a licensed attorney, which means that he can reciprocity through Tennessee and other states. So his goal now is to continue in the legal field and not consider CPA anymore. He actually did not, was not in the practice of accountancy for numerous years. He was just an executive in this company that, of course, is all the legal issues. But he's stressed to me numerous times. He's actually been very cooperative and as much as he can in this situation. But he stressed many times, and he's actually said that he was going to not renew his membership in certain associations that have accountancy.
So he also is, I checked this morning, he still is a licensed CPA in Maryland. So how does that affect anything here? I mean, if he's living and working here, he's not supposed to use the designation in Tennessee if it's closed.
He stated to me that he was not going to renew his CPA license in Maryland, that he was strictly going to go legal, be an attorney.
Do we have proof that he is licensed to practice law?
Yes.
Okay.
Would it be appropriate to wait until we get verification of the fact that he has let the Maryland license go before we go forward, and then maybe at that point, or do you still feel very strongly that if we close and flag, that we still have the appropriate measures to go back against him via that or the court once the appeal is over?
That's a great question. I feel very strongly that we're good with the closing flag feature. I think that the Maryland license is the Maryland license. It's not really going to be used here in Tennessee. So I just feel like we are okay, that we will be okay with the closing flag. And I can always request, just verbally request, hey, give me proof. I believe he will give it to me. I mean, I've had numerous conversations with this person and with his legal counsel. They've been very cooperative.
So just to confirm one more, the only thing that bugs me is where we say he'll agree to reappear before the board. I mean, he can satisfy that by coming in here and reappearing before the board and leaving. It doesn't say what our options are at that point. I mean, what leverage do we have on him at that point? If he reappears, is that all he has to do?
Well, if he reappears, we'll know a lot more information at that time. Right now we're speculating. If he appears, well, at least something has happened for him to reappear. So it really depends on the information that we would have at that time. If
Still have the option to reinstate or not.
yes,
Okay.
You just said earlier that you couldn't answer that question. That about if he were to reappear to reopen the license, can the board choose at that time not to reopen the license based on this reopening this complaint?
well, I took the question as it's at that time they could either reinstate or not. I would think that I could probably look more into that situation, but I would think that if the person appeared, was flagged to appear and was trying to reinstate their license, I think the board at the time does have discretion whether or not to reinstate or not, or if there was information that was out there, because at that time I would think that the order is either null and void at the time or it's not. So that would be the option of the board. If the order is null and void, then you may have that discretion to reinstate. If the order is still out there and is valid, then you would have that discretion to not reinstate. So really it just depends on at that time whether the order is valid or not.
I think the bottom line is that the respondent is not able to practice in Tennessee using this Tennessee CPA license until he appears and until the board, takes appropriate action based on its deliberations, if and when he ever does. And it sounds like he's not going to ever do that because he has no intentions of continuing to practice as a CPA in Tennessee.
That's correct. Both of those things you said were correct.
What's Maryland doing? Are they following this case, or?
I have not talked to Maryland, or I'm not sure.
I tried to reach out on one occasion and did not get a response.
It's like, with mobility and everything else, we're letting somebody down here. If he's still a CPA in Maryland, without Maryland, because of knowing.
I was going to say, Maryland would have had the same notification we had of this. We get it
So
from
we
the
just
same
don't know what they've
source.
done.
Yeah, they may have decided not to do anything with it. I don't know, but they get the same notification that we get.
Yeah, and when I inquired, I provided the SEC order to them and just did not get a response. And different states just handle things differently.
Kevin's point is important, which Stuart's made also. Respondent's license has been closed in Tennessee.
And I think that's something to say that he voluntarily closed it. He could have reinstated, but he actually voluntarily closed it himself and notified me of that.
Well, I've gone through this. It's about as clear as mud. Any further questions? Okay. Well, then I would request a motion to approve the 3 re-representations as recommended by council.
Mr. Chairman, I move that we accept the recommendations for cases 9 through 11.
All right. And then, do I have a second?
This is Janet. I second.
Okay. And ask for a roll call.
Andy Bonner.
Aye.
Janet Booker Davis.
Aye.
Pamela Church.
Aye.
Greg Gilbert.
Aye.
All right. Mr. Chairman, I think that concludes the legal report after many technology difficulties. I think we finally gotten there.
I appreciate the work of staff and council, and also appreciate the diligent work on the committee members and other board members for asking questions to try to make sure that the actions that we take are appropriate. So thank you, Andy, for leading that. Let's go ahead and take a 10-minute break. I'm showing it's about 3:17 Central, so let's take a break until 3. Why don't we just make it till 3:30 to round it up, and then we'll resume at 3:30. Committee meetings and get everybody to resume here. We've completed the committee work with respect to the licensing and enforcement committees, and now we'll proceed with the Laws and Rules Committee, which is chaired by Larry Elmore. And Larry, you've got a draft rule change, I know, on your agenda, and I'll turn it over to you and your committee.
Chairman, you caught me by surprise. I didn't realize I was up next, but that's okay. I've recovered.
Okay, all right. One thing we should do is just double check to make sure that we've got our board members on the phone still with us. So Janet and Stephen and Pam, if you could chime in and make sure you can hear us so that we can hear you.
This is Janet. I am here.
Great.
And this is Stephen. I'm here as well.
Thank you, Stephen.
This is Pam, and I'm here.
Outstanding. Thank you, Pam.
Mr. Chairman, we have, it looks like, another call-in individual. Could we at least get that person to identify themselves? Maybe Laura can note that.
Thank you, Wendy. So if you are external to the board and are calling in and could identify yourself, that would be greatly appreciated.
Okay. Maybe later on.
Okay, if you remember, in our May meeting, this draft rule was originally proposed as something for the board to address. And just going back a little bit in history, just to bring everybody up to speed, the AICPA and NASBA released their CPA evolution model curriculum back in June. It's like 94 pages long, so this is not nearly as bad as that, but one of the reasons we're trying to change this language here is not only to update it into the modern era, but also support that evolution project to make this more in line with that. Their analysis back earlier than that even said that when the exam was changed, or it will be changed under the new process, that many of the universities and colleges in our country, that there's a wide gap between what's currently being offered in the curriculum and what will be needed to be offered in order for students to pass the exam under the new standards. So one of the reasons for their project was to shrink that gap, and because, I mean, if you actually count the time, what's coming forward, rising sophomores right now in school, in college, will be the first people to take the exam under the new project. So the time is now to get everything to ready for that. So you see at the top of this presentation that we have, it's not only to support the evolution project, but also to adopt new language to reflect current practices and accreditation and so forth, and current board practices. So if you look at the changes, if you remember, we looked at this in May. We talked about the language that was used. And if you look at the track changes copy that's here, in your presentation materials, the red and the blue that's in here before was what was presented last time, and then staff has gone through here and added some comments on changes that were made since then. And I think all of them have a comment added by Wendy. Wendy's WG1, WG2, WG3. There's one of them that doesn't have the WG1 or 2 on it. Up here in paragraph number 5 on the second page, we added a little, you'll miss it unless you read it real carefully, but there's a paragraph 2, it's in blue there, that we added also. We didn't add a paragraph, we added a paragraph reference. So these are mostly just cleanup, adding things like one. And I guess I'm leaving some things out here, but Wendy had sent this proposal to the area colleges and universities with accounting programs, and sent it to all the major ones, I guess, that we had contact available information. And we received a couple of responses, but not a lot. One of the complaints that we had, not a complaint, but a suggestion, was that as opposed to the way it was reading before, you could actually look at it and say, well, we were dictating courses to be offered. Our intent was to suggest course areas of reference and so forth, subject matter content. So that was changed here to make that more clear. We added a principles and introductory planning class area, and then mostly just clarity. So I guess, we can address any questions anybody has on this. We replaced the reference to senior college as opposed to junior college. We took out senior college and just said 4-year degree college. So anyway, we need to address the changes that we ask legal to make, which I think they've done a good job with, working with Wendy on that. So anybody have any questions about the revisions that were made? Any more suggestions? And then I'm going to turn it over to Wendy to proceed with this. And then we need to make a motion at the end of the discussion about what we do tomorrow about this. So.
You ready for me?
I'm ready for you.
Okay. I just want to make sure that I cover one of the major concerns that we received from Lipscomb locally. And I thought it was worth making sure you all completely understand. So one of their concerns is that when we go to list the courses, which we changed to subject matter content under education, and under the 20-02-.02 education, in 1A, we then list out a number of course content areas. And the concern raised by Lipscomb was that in number 4, we mentioned taxation, which might lead you to believe that that would be all-encompassing of all taxation courses. But then we go down in number 10 and we say tax and financial planning. And then 15, we say tax research and analysis, which could then cause someone to believe that only those 3 types of tax courses would be acceptable. So there was some concern there. We internally feel like we alleviated that by changing the following courses to the following subject matter content areas. To help broaden that a little bit, not to say that a course has to be named something like that, but these are suggestions of topics that would be covered in courses that would count. And let me also explain why I think it's this way. In the model rules, they're even more specific than we are suggesting. So in the model rules, you're required to take 3 hours in each of the items in 2, 3, 4, and 5. And then in 6 through 18, you're required to take an additional 12 hours. So they get more specific, which is why I think that taxation and those content areas were separated like that, or handled in a duplicate fashion, if you will. So
in the NASBA document, they break this down by core and also by discipline.
Yeah.
So it's very detailed.
Yeah. Anyway, I hope that we clarified that in a way that doesn't mean that international tax wouldn't be accepted. That's not the intent. I don't believe, and I don't think it wasn't our intent, and I don't think it's the intent of the board. So that I just want to make sure I brought that up.
I think you did a good job, and legal's help too, in clarifying that these are not course titles. These are course areas of content. And that's the key distinction there. And I think that was our main issue before, which has now been corrected. But I was really surprised we only got two colleges and universities to respond with comments to our document. So
I like that they did address that because that was really a good catch there.
I agree. I agree. Not something I had thought about before. So I think
But
overall. Go ahead, Pam.
I was somewhat surprised at the reaction and the strength of that reaction because I saw listing a lot of different courses as providing good guidance for the candidates, for when they were trying to decide if a certain course would qualify. And that avoids having them come ask us every time they take a course, because we have to remember that they don't have to have a degree in accounting from a particular school. So I think I would be concerned if we didn't have number 18 with the other category, but it seems like by having a lot of different ones, that it gives people an idea of what is okay. Am I wrong?
I would agree.
yeah, and I think number 18 is our ace in the hole.
Right. Anyway, I like the way it's written, and I like it better now. I think you've done a good job.
And is it the intent of the board, really, for all intents and purposes, if it's a tax course, it would be acceptable? Yeah.
Was there any questions anybody, either on the committee or not on the committee, has about the document, and any suggestions that we make? Anyone on the committee have a suggestion for how we proceed?
That just made me think of a question. If somebody took a tax course in a law school, does that count?
Isn't this just addressing four-year universities? So I don't think it would include any kind of law school, anything. Am I wrong there?
I've never thought of law courses as counting, but it just hit me that we don't really say that. But I don't think that anybody's document addresses that, but it might be a question, but if we've never had to consider it, that's okay.
I'm thinking that might be something we address if it comes up, meaning that it would be a course that would come before the board.
One thing I would note, just reading the draft of the proposed rule on page 2, near the bottom under education, subparagraph 1, it says an applicant will be deemed to have met the educational requirement for the purpose of being eligible to receive a certificate pursuant to the statute if the applicant has earned a baccalaureate or higher degree from an accredited educational institution and obtained the minimum number of hours required, which includes, and then that's where we list the various courses. So I don't know that a law course would necessarily be precluded, the way I read that. Assuming that the law student already has a baccalaureate degree and meets the other, educational requirements.
So, Kevin, how do you feel about accepting something like that without board review? Because I think that's how it reads.
If it were a tax course in an accredited, law school, I'd feel very comfortable with that. Now, it may be very specific. It might be real estate tax law, or it might be, merger and acquisition related. But I think that fundamentally that would be a legitimate course and probably a little bit harder to get through than an undergraduate course on taxation would be my speculation.
And I think the way this reads, it would automatically be accepted based on how everything reads. Okay.
Well, the first paragraph, page 1, says recognized colleges and universities and defines those in the next 4 or 5 paragraphs, which sort of differs a little bit from that paragraph you read.
I'm thinking most law schools are accredited by the same groups, wouldn't you think?
But the title on the very first page says recognized colleges and universities. It doesn't say law schools. Is that okay? I mean, a law school is part of the university,
right.
part of the college.
So is the Haslam College of Business.
Yeah.
You know,
Yeah.
so I think it falls under. Do you have any thoughts, Maria?
Sorry, I wasn't prepared to go down this route today, but just off the top of my head, I'm pretty sure law schools are ABA accredited, which would not be in this list. However, sorry, I just want to make sure.
But they're typically housed in a college or university.
Yeah, it could be
right?
under, like, I'm just thinking of Belmont, you know, they're under
Yeah.
the umbrella of Belmont University.
That. Right, regional accreditation, that.
Right.
This is Tony Glenn. I could tell you what my law school did. The University of Memphis is the Cecil C. Humphrey School of Law, which is housed in the University of Memphis, and that law school itself has its own separate ABA accreditation, which means that attorneys graduating there could sit for bar exams and be licensed in other states outside of the state of Tennessee.
Thanks, Tony.
I don't know about Tennessee, though.
You know, there again, we worry about law schools, real estate schools, everything in the document. Got a document we can work with that if there's something that needs to be brought to the board for approval, that Wendy and her staff can do that without it being cumbersome. I think we could be here forever trying to cover every type of school that we would need to cover, or that opinion. So, where's my committee at? Comments, questions?
I think it's very well written. Now, I really appreciate the addition and the change to course matter and that sort of thing. I think we're ready to approve it. I would make the motion that we approve this draft rule change.
We have a motion to move this approval to tomorrow's board meeting, and I need a second. Motion and a second. All those in favor, aye.
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 Aye. I thought maybe we didn't have a quorum, but we do.
Okay.
Any opposed in the process of moving this for a vote tomorrow to the full board? Motion passes.
I'm just going to give an update on the state-specific ethics course rule that we have been working on. I think it was in May we had a rulemaking hearing. Right now, it has been filed with the Secretary of State. So post-rulemaking hearing, we received approval from the Attorney General's office and signature from the Attorney General, as well as approval from the Governor's office. So it has been filed with the Secretary of State. Its effective date is 90 days from the date of filing. So I'm not sure the exact.
October 6th.
Okay, October 6th. And so we should probably, that's pending approval of the Joint Government Operations Committee. So Wendy and I will attend that most likely in September. So 2 months from now. And we haven't had any problems, but that will become effective October 6th, pending approval from Joint Government Operations Committee.
Okay. Thanks to Wendy and thanks to Maria and your staff, both of your staffs, for bringing this back to us with a much improved document that we can move forward with. So, Mr. Chairman, that's our report for the day.
Thank you so much, Larry and committee members. We'll go ahead to the executive committee reports, which include financial results, for fiscal year 21, and we've had some excerpts of those included in the board read-ahead document for everyone. Wendy, are there any highlights that you would like to make with respect to the year-to-date board financial reports that we have in place? Looks like through year-to-date through May at this point, given the timing of our meeting and the availability of subsequent data.
Yeah, I'll give a quick overview and then let y'all ask questions if you have any questions. And just overall, our total revenue as of our fiscal year end is June 30. So as of May 31st, we're at $941,084 with expenditures at $762,594, which leaves us on the positive side at $178,490. It looks like our expenses at the highest range about $80,000 a month. So we're looking at just around $100,000 that will probably move to reserves. And so really the only place we've seen some increase this past year has been technology. We had a significant upgrade to our platform. We had a lot of issues with that. So we just, across the board, there's a lot of technology increases. Of course, we've saved in travel and those types of things, and everything else is pretty status quo. So were there questions with any of the information I provided?
I think given the kind of the unpredictability, both in terms of revenue as well as certain types of expenses that you mentioned, Wendy, such as travel, to be within $100,000 of where we thought we would be when this budget was set is reasonably close in my mind.
I had one question on chargebacks.
Yeah.
That's always something that's either a big help or a big hurt to us every year. It looks like when we budgeted that, we budgeted quite a bit more than what it looks like we're going to turn out having. And I didn't really see an explanation for that. I think you addressed the difference, but you did. I didn't really see. Were we just a little pessimistic about that on the front end? And it looks like it's going to turn out a lot better than what we budgeted.
Yeah, I think that we were just pessimistic. I think we have been advised internally that to expect some increases in IT costs, and I think we were planning to see some of that, and we have seen it, but we've seen savings on other parts as well. In fact, I think I mentioned in there that our legal costs have really stabilized, and that's really good to see. But I think having just Maria on our legal team, and not just Maria, I mean, she has a paralegal, and Stuart helps. But for the most part, Maria is the one handling our board from the legal perspective, and that has really helped, both in terms of education and having one person responsible for everything, but also from a cost standpoint, it helps stabilize that cost. So we've seen a lot of savings there compared to the highest levels that we had seen.
My only other question was rent.
Yeah.
Rent's a little bit confusing to me because we're not using all this space we had before, but yet this rent in here now is comparing it to last year, and you're not seeing what year did we see, or did we see a big decrease in rent when everybody went home and worked from home?
So it would have been the last fiscal year. So it did take some time to see any savings related to that. Basically, they had to get everybody home before we started seeing a savings in our financials. So we were paying a little over $3,000 a month in rent, and then it decreased to somewhere around $1,100, and then for some reason we saw an increase the past fiscal year to about $1,300 a month.
Charging us for rent at home? Is that what's going on?
We still occupy a certain space in the building, and so they've, we were cut in third basically when we went home. We still have to pay for a certain amount of space. It is anticipated that we are going to move again and further condense the space that we, as reg boards in general, take in the building. So we have some storage area. We have an office that we can come into. But hopefully, if we're going to condense a little bit more, we might see a little bit more savings in rent as well. But yeah, we still have, because we have a place to come to, we still have to pay something.
Long term, is the plan to continue to work remotely?
Yes, for the foreseeable future, yes.
Okay.
So
one thing on that front, I mean, I think I think guessing why it may have gone up a little bit is because whereas some other group would have taken over some of that space, they didn't. And so people, that couldn't offset the cost. And as people start coming back to the office, if our reg board is going to be mostly remote, I think we will see a decrease if that space is occupied by other people. I think COVID really messed up the process on that. So I think we would have seen a decrease had COVID not come. That's my thought.
I haven't gotten an official answer. I have requested that someone look into it and have not gotten an answer as to why we saw an increase. And I think, Greg, you had asked at the last meeting maybe about, using some of our money to purchase computers or something before the end of the fiscal year. And I did look into that. And of course, that would have been an example of something we might have been able to use the money for. But with new legislation that went into effect this year, we are going to be able to use our reserves for things like equipment purchases, more like one-time purchases. And so when I asked about that, they said, well, you're going to be able to use your reserves anyway for that type of expense in the future. So there isn't a need to do it now. And there aren't a lot of other expenses that there was much fluctuation that we could have done much about. And I think I sent out to you, the legislature we initially staff did not receive raises back in January due to COVID, but the legislature did approve an increase as they closed out their budget during the session. So that will be reflected in our June financials. So those expenses for June may be, because it was retroactive, so that may end up being our highest month from an expenditure standpoint due to that.
Thanks, Wendy. Any other questions with respect to fiscal year 21 year-to-date results? I think the last item we have for this part of the executive committee report relates to travel. And Wendy, any comments with respect to that?
I just wanted to bring up that, so we have the NASBA's annual meeting coming up in the fall, and the budget that we have in place, which was approved, allowed for 4 board members plus the executive director to attend that meeting. We have one additional person interested in attending, so I think that it might be good for the board to discuss. Are you willing to allow an additional board member to go? It's roughly $2,000 for each board member to attend that event. So that might be something the executive committee wants to discuss and approve at this meeting. And so if the annual meeting goes on as planned, then we can allow everyone to go that has indicated to date that they'd like to attend.
Thank you, Wendy. My view would be that actually attending is a healthy thing to learn more about what it is we do here, but also the relationship that we have with NASBA and the AICPA. So I personally would be supportive of that. But let's open up the floor to other board members to see if there are other comments. I think if someone's willing to go and meet the requirements that they'll need to meet for NASBA's board meeting, they ought to be permitted to within reason. So
I agree, Mr. Chairman. I have always encouraged as many people to go as possible because I've been to a lot of them, not only just annual but regional, and you meet people that you wouldn't otherwise meet that are influential in NASBA that can help you with understanding the processes that they deal with and just the CPE that's there. If you just go for the CPE, it's worth it. I mean, you learn all about NASBA, how it operates. You learn about a lot, and people that are new board members, there's a great training for that. And I don't know, did you go to that with the regional? Okay. So I agree with Kevin. I wish everybody could go. I wish everybody would go.
I think the other thing to note is also, we didn't have an in-person NASBA annual meeting in the prior year either. Yeah. So there's probably a little pent-up demand there going on as well.
I'm surprised that not more than one person, in addition to the ones we've discussed, has asked, because we have so many people who are members of NASBA committees on this board, which is great. Also, I think have that kind of participation.
Hey, is NASBA back in house, or are they still remote?
I think they have remote options, but for the most part, I think they are back working in person. Andy, do you know anything more than that?
Yeah, they're back in-house. If an individual elects to be remote, they can still be remote. All of their senior staff people are back in-house, and they are traveling again. They have opened up travel.
Good. That's good.
You know, I would go ahead and chime in here and just say I agree also. It's one thing to sit. I know that we had almost 100% participation for the regional meeting. There are a lot of things going on in our profession, a lot of changes, CPA evolution. There's going to be a lot of information that can be gathered at the annual meeting. And of course, you could say, well, gosh, you could do that remotely. The problem is that on a remote kind of cast, we didn't get a lot of conversations, and being there allows the board member to kind of talk to others to find out, well, what do they mean by this, or how would that affect a state? And so it gives a lot more information about what's going on in the profession, specific to changes that are going to be mandatory at 1/1/24. And so I think that the people who are willing to give up their time to go out to learn more about what we do here and the changes coming that will affect our duties here, then it would be great for us to support that specifically, since we didn't have any travel this year. And I agree with that statement. So I would say yes, so we should amend the budget to allow for an additional person to travel.
Any other comments? If not, we'll take a formal motion then to allow up to 5 board members plus the executive director to travel to the NASBA annual meeting scheduled for later this fall. Is there a second?
I'll second it.
We have a motion and a second. I think all those in favor say aye. I think we've got a quorum of the executive committee in house. So all those in favor say aye.
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 Any opposed? Okay. The motion passes for recommendation for board approval tomorrow on that. I don't believe we have any other items for the executive committee. Tomorrow morning, I think we start at 8:30 a.m. Is that right?
That's correct. And we do plan to have some breakfast here for you all in the morning.
Great. Stephen, Pam, and Janet, thank you for bearing with us on the phone throughout the entire afternoon. We appreciate that very much. And board members in person, great to see everybody in person along with staff.
Hey, Wendy, can you fax me a biscuit tomorrow?
I'll try.
All right.
See you guys.
See you. We will go ahead and adjourn our committee meeting sessions.
Goodbye.
Bye-bye.